See advantages in dispensing with a jury in the Irving case.
I don't want to sound as if I'm being condescending, but to 12 amateurs to come in and to wrestle with the huge number of documents, to focus throughout on the points that they were going ultimately to be asked to decide, and they were very numerous. It wasn't a do you find for the plaintiff or for the defendant. It was much more complicated than that. I think would really have been beyond the powers of any 12 men and women. That is not to decry the jury system, but there are advantages in having a judge decide cases. The particular advantage, I suppose, in this case might be said to be that at the end of the day you get a reasoned judgment, which you don't with the jury. Juries don't give reasons for their decision.
I mean, in terms of a judge who might have heard this trial, were you the most junior of the three who might have heard this trial?
That's right. There are 3 judges who do a lot of this kind of work. And I was at that time, and still am, the most junior of the 3. Your unasked question is why was I chosen? The answer to which is I just don't know. I just don't know.
So were you, surprised that they chose you?
Not particularly, not when I was asked, I wasn't, because I don't think I then realised that it was going to be quite as massive and as significant a trial as it ultimately turned out to be. I think I had about 6 weeks of solid reading of the background material. And I think that will probably have saved the litigants weeks of expensive trial time.
And how good is your German?
I don't think that was any reason why I was asked to do the case. It's probably good O-level, A-level kind of German, far inferior to David Irving's German, which is absolutely fluent. But knowing German did help a great deal because a lot of the documents, as you probably know, were in German, not all of them translated. And it also helped, I think, to have a little bit of a feeling for some of the important words and how they might be translated, not in a dictionary sense, but in terms of the feel for the thing.
The case opened in a packed Court 37, the largest in the High Court in London. David Irving's opening speech on his own behalf lasted more than 2 hours. He accused the defendants of being part of an organised international endeavour to destroy him by spreading waves of hatred and being responsible for publishers dropping his books. After a somewhat shorter opening speech by Richard Rampton, Irving called his first witness, himself. He was playing up his status as the litigant in person.
It enables you to put on a nice optical display. I was very careful in the courtroom to ensure that there was a 5-foot clear space all the way around me. And when my friends who came into the courtroom shoveled their chairs up close behind me so they could whisper, I made it pretty plain to them that I wanted them to pull back. I wanted the public and the press to see that there was me on the one side and there was the 40 people on the other.
So David and Goliath?
David and Goliath, and as I said, David doesn't always win, which is a sentence I have to admit that I prepared some weeks ahead.
What is your attitude as a judge to the litigant in person?
It's a problem which confronts judges day after day. And it undoubtedly does add to the judge's burden because he's got to make absolutely certain that the litigant in person is not being disadvantaged by being a litigant in person, which means that you've got to make sure that he understands what the law is and what problems the law may be presenting for his case.
The High Court now became the kind of very public stage that David Irving relished. But though there was huge reporting of the case, it was not to Irving's taste.
I would say that the judge was in awe of the British press. I complained on repeated occasions in the early stages of the trial about the vicious reporting of the case by the newspapers, and the judge's attitude was, well, it's not affecting me, the judge, therefore I'm not going to do anything about it, because if I say at the end of this trial David Irving is right, the world's press are going to say British judge says Holocaust never happened. I think the press have behaved, frankly, like SH-1Ts. They behaved like shit throughout the reporting of this trial.
One of the things that struck me about this whole case, obviously, was this extraordinary, huge media interest. I wonder what effect that had on you as a judge.
It is, in a sense, daunting. But if you ask the question, well, does it really make any difference to the judge that various parts of the evidence have been misreported? The answer is, I think, no, because you were there when the evidence was given. You know what was said. It's just an added, if you like, irritation that you've got to deal with these sort of problems. And the litigant's complaint that his case has been misrepresented, perhaps at the beginning of every other day. But beyond that, I don't think it was a problem.
David Irving had spent a great deal of time preparing for his cross-examination of Deborah Lipstadt. and he was looking forward to her appearance in the witness box. But to his chagrin, Professor Lipstadt and her defence team decided that she should not go into the box to give evidence.
It was an inevitable consequence of the broader litigation strategy, which is to put Irving's books on trial. Deborah's book spoke for itself. It was all that she wanted to say, or she needed to say about Irving, and therefore, for the purposes of the trial, she had already given her evidence. The evidence sat in court as the book.
Richard Rampton, QC.
The defence of words which are said to be true is an objective exercise. It's not a question of what she thought or believed when she wrote what she did. The question is whether what she wrote, when she wrote it, is true or not. And that's an entirely objective question. And for that purpose, Deborah Lipstadt was not a necessary witness.
So what was David Irving's reaction when he learnt that Deborah Lipstadt was not going to give evidence?
We knew it only at a relatively late date, which was technically annoying for me because we had to spend a great deal of effort, I and my friends, in assembling a dossier for cross-examination of her. I don't think that her Brooklyn accent would have endeared her to the court. She kept literally silent for 3 months in that courtroom.
First of all, I'm not from Brooklyn. It's not a Brooklyn accent. And if that's the way British law is decided, then it's a very sad day. I don't worry about the way I enunciate. It's good enough for the BBC. I think it would have been good enough for the British court. But the fact of the matter is, I wanted to go in the witness box. A number of times during the trial, I said to Richard Rampton and Anthony Julius, if he's going to make a big fuss about the fact that I'm not going into the witness box, and if you think that's going to harm our case, I'm more than happy to go in. And I'm sorry I couldn't go into the witness box, because I think I would have had no problem besting him.
That was not how Irving saw it. He'd worked up a detailed dossier on Deborah Lipstadt using the discovery process. He'd planned to try and demonstrate that the fact that she was Jewish had caused her to write what she had about him.
I'd obviously spent many months building up a dossier for cross-examination. She's Jewish, of course. She's professor of Jewish studies at a university in Atlanta. I was going to get answers to the questions I needed her to answer. What is the most important prayer that is intoned on Yom Kippur by a religious Jew like yourself?
You obviously know a lot about the Jewish religion.
I know nothing at all about the Jewish religion,
really?
And nothing at all. I find them interesting people, but also endlessly boring. They go on and on and on about themselves. And I've said the reason they go on about the Holocaust is because it's the only interesting thing that's happened to them for 3,000 years. I'm not interested in the Holocaust. I don't know of anybody who is interested in the Holocaust, except in a kind of clinical way.
Very early in the trial, I had emerged from the courtroom, and friends of mine introduced me to a professor who was standing on line from Newcastle, and we came to the courthouse, and they had made friends with him. When I came out for the lunch break, my friend was sitting on a bench with him, and he was weeping. She called me over, and the last thing I want, this was day 3 maybe of the trial, was get involved in someone else's emotional upset. I really wanted to focus on the trial. My friend insisted come over, so I went over. The man was very embarrassed. He said, so much of my family was killed in the camps, and this was so hard to hear and to listen to Irving. I said, don't worry about it. I said, look, I'd love to stay and talk to you, but I've really got to run. And he said, I know, I understand, but can I ask you one question? And I said, of course. And he said, my family came from Hamburg. And my mother always used to talk about a Gustav Lipstadt, whom she called Mr. Handlebars, because he had a big handlebar mustache, and he was very kind to the young people and the children, and she remembers him very well. Is that any relationship to you? And then I couldn't talk. Gustav Lipstadt was my grandfather. And, excuse me, I never knew him. But, you know, who would have dreamt, excuse me, that suddenly into a British courtroom, my family would come parading, you know, and it was a powerful moment. It was a very powerful moment. So, when you